Good morning, everyone. I can see people starting to filter into the room, so I'll just give it a few more minutes while we have a few more people joining us. I'm expecting about 10 people this morning, so if we can get a few more in the room before we start recording, that'd be great. Today, we'll be discussing the compliance requirements for employers under the Australian immigration system. It is, from my perspective, quite an interesting area. It's a fairly new area for many employers to start thinking about compliance. It's not something that has historically been top of mind for many people, whether it be in HR, whether it be even in areas such as risk and compliance, to think about. I was having a discussion this morning actually with a US firm who have recently entered the Australian market, and I think they have about 40 employees in Australia at this point, and they've really only just started to realize the way that immigration affects their business, and affects their business not only in terms of the people that they're bringing in from overseas. So it is an interesting area to be exploring with experienced HR practitioners who are really sort of getting their head around the whole area for the first time. So we've got about 7 people in the room now, which might be as many as we get. So I'll kickstart things without any further delay. I want to keep this short and sharp for you all during your lunchtime. We'll try and keep the run time to about 45 minutes, and then we'll save a few minutes at the end for any questions that you may have. So in the meantime, feel free to please, pop up your questions into the chat. I should be able to see the chat and answer any questions as they come. So bear with me while I share my screen. Excellent. So welcome to today's lunchtime briefing. This is the second session that Rome Migration Law has had as we go through a series of webinars for employers on different aspects of Australian immigration. Last week, we had an introduction to the broader immigration system for employers and the relevant visas. And today we're going to look at immigration compliance. We've scheduled for next week, we will be looking at a session on sort of what's new in the immigration space, which is really relevant now, I guess, both given that we've come through COVID and there have been a number of changes there, but also due to the fact that we now have a new government and probably quite a different approach to immigration as a result. So I look forward to sharing that session with you next week. But today, overview of immigration compliance. So our learning objectives today will be to, first of all, just touch on immigration compliance. What is it? What does that mean? How do we look at immigration compliance for employers? Then we'll drill down into the 3 major compliance frameworks within the Migration Act and regulations. They are what we call the employer sanctions regime, the sponsorship obligations, and the charging for a migration outcome provisions. We'll talk about some future changes that were actually flagged about this time last year, and how they may affect businesses going forward. We'll talk about managing risk at a more general level with regards to immigration matters. And then we'll talk about some of the ways that you can perhaps look at addressing immigration compliance within your own organizations. So, introduction to immigration compliance. Now, this slide is actually the same as last week. And the reason that I thought that it was necessary to include here is because it really sets the ground, the groundwork for what is immigration compliance about. And this is really relevant if you haven't worked in this space before. And it was quite interesting on the call that I referenced earlier this morning with a US law firm, sorry, not a US law firm, a US firm who have established a presence in Australia. And it was very interesting because they don't necessarily have in the US. We had a US practitioner, a US HR practitioner on the phone. We had an Australian HR practitioner, and we have somewhat different concepts around residency status. And so it is important to set out what that means. So Australia operates a universal visa program. That means that anyone who is not a citizen needs a visa to come into Australia. And when you come into Australia, you will either be lawful if you possess a valid visa or unlawful. So people might be unlawful on arrival, for example, if they arrive on a boat seeking asylum in Australia, or they might be unlawful if they've arrived on a particular visa, whether it's a student visa or a visitor visa, and then they overstay. They don't return home before the expiry of their visa, or they they deliberately let it lapse, or whatever it may be. And then at that point, that person becomes unlawful and they don't have the right to remain in Australia. They can be, if they are located, they can then be detained and deported. Okay, so we've got lawful and unlawful. Now, if you're lawful in Australia, you're going to have one of 2 or 3 potential visa statuses. You might be a temporary resident, which is to say you hold a temporary visa, and that visa has a specific end date. Now, that end date may be based on an event, such as, you can hold a temporary partner visa until the permanent partner visa is decided, for example, or you might hold a student visa, which is valid until, March 2024, because you're in Australia and you're studying a bachelor's degree, for example. There's also what's called bridging visas. Now, bridging visas are temporary visas. The reason that I've marked them out as different from the standard temporary resident is, in most cases, bridging visas aren't something you can actually apply for. In some circumstances you can, but most often a bridging visa sort of bridges the gap between one visa and the next. So that student whose visa is going to expire in 2024 may want to stay on further because they're going to do a master's degree. They apply for another student visa towards the end of their current student visa. They receive a bridging visa, which then bridges that gap between the end of the old temporary visa and a decision on the new student visa. Permanent residents are people who have applied for and obtained the right to remain in Australia for the rest of their life. And that typically carves them out for the purposes of employers. So once someone is a permanent resident, you don't really need to think about them as an employer in the context of most of these aspects of the immigration compliance we're going to talk about today. And then, of course, you've got citizens. Being a citizen is the most full part of being a member of the Australian community. It's the most full status, and it marks you out as a member, a permanent and ongoing member with specific rights that permanent residents and temporary residents don't have, such as the right to vote or the right to run for political office and various other things. So that's the framework. Now, within that, we have 3 particular types of compliance obligations. And I'll run through them from left to right on the screen. Employer sanctions. Now, the name here doesn't mean much, but basically it's a law that was set out in 2013 that says that employers can only employ non-citizens, i.e. visa holders, who have the correct visa and work rights. Now, there's 2 parts there. So you have to have a valid visa, okay? You can't be unlawful, going back to the last page. And if you do have a visa, you have to have the appropriate work rights. So the example there would be a visitor visa where you don't have any work rights, you can't perform any work. So if someone walks into your organization, they say, I want a job, great, no problems, here's the mop and broom, you can start now. You need to, in order to comply with the law, you need to check that that person has a valid visa. Okay, and that's the second dot point there. Requires employers to verify visa status of all employees, contractors. Now, the only way that you can mount a legal defense if the government finds that you have been employing someone who doesn't have a valid visa or work rights is that you've taken the steps that are set out in the legislation to demonstrate that you attempted to find their visa status. And that is by running what's called a VIVO check, or Visa Entitlement Verification Online Check, using the department system, or citing specific documents such as an Australian passport and so forth. So that's the first framework, and it's to do with only employing people who have the right to work in Australia. The second one, charging for a migration outcome, is related to an effort by the government to stop people from perverting the visa system. And what I mean by that is when you sponsor an employee, you are supposed to have, as an organization, a genuine need for that person in that role. And so this is designed to stop people from offering, requesting, giving, or receiving a benefit, whether that's money, a favor, whatever it might be, in exchange for sponsorship. So under the immigration system as it operates, you are not supposed to be able to give your cousin a job, for example, because he wants to migrate from somewhere. You are supposed to only make an offer where the person is the right person for the job. There are no Australians available for the job. And in essence, these laws are designed to stop people from enticing an employer to give a job, or for prevent unscrupulous employers from trying to gain a benefit from offering sponsorship to someone. A lot of these offences, the onus of proof is reversed, which means if the government comes and says you have done this, it's actually up to you to demonstrate that it has not occurred. And the only defence here is if you can demonstrate that the business has actually taught staff that this is prohibited, okay? And we'll talk about that a bit more further down the track. Sponsorship obligations are the third framework. This is a set of rules and requirements that employers must agree to if they want to sponsor people on the subclass 482 temporary skill shortage visa, the new skilled employer sponsored regional visa, or an activity visa. If you want to sponsor those people, you have to agree to abide by the obligations the government has set out in the migration regulations. And these are mainly around record keeping, notifying the government of certain changes, cooperating with inspectors, but there are a few others there, such as paying return airfares if a person decides they want to go home, or potentially covering the costs of detention if the person does a runner and doesn't want to return home. So there are both quite sort of minor administrative requirements as well as bigger picture potential risk factors to be considered. And if you don't comply there, you can basically be barred from sponsoring, or you can have your sponsorship cancelled. So moving on, what's relevant? What's all of this about? What's compliance about? Well, ultimately, it's about managing risk. It's about making sure that your organization understands what the risks are and implementing a system to control those risks. Now, we know that risk takes different forms. In immigration, it can take primarily, I would say, three forms. The first one is the relevant penalties, whether they be fines, warning notices, or even criminal penalties for serious misconduct. The second one is operational. And this is because more and more organizations in Australia rely on temporary visa holders. We know for a fact, for example, that the healthcare sector is probably the largest single user of sponsored visa holders in Australia. If you are using visa holders to fill critical roles, whether that's as a surgeon, whether that's as a CEO, whether that's as a software developer, losing access to the program can cause enormous operational risks. And so managing your compliance is really important. And the last one I would frame as an ESG risk. Many organizations today recognize that consumers are fickle. Consumers want organizations to be doing the right thing from a social perspective, from an environmental perspective. If you are found as an organization to be non-compliant with your immigration obligations, then there's a real reputational risk there. And I think, 7-Eleven is really the classic example in Australia. The losses that were incurred in terms of direct payments were in the hundreds of millions of dollars. And the ongoing reputational damage as a result of the revelations that came out in sort of 2017, 2018 are really significant and probably ongoing. So how do you manage risk? Well, there's a fairly standard set of tools, policies and processes to establish controls and ownership, risk assessment, so actually taking that bigger picture look at what is happening across this immigration space and where the risks may lie, and then following up on a regular basis to do auditing and monitoring of your visa holder population, of your immigration systems, policies, and processes to make sure that nothing's falling through the gaps. Unfortunately, one of the big challenges in this space is that no one really wants a whole new area of compliance liability. Unfortunately, it is a reality. It's a reality in terms of the laws are there. It's a reality in terms of the enforcement is there. And because of the nature of those risks, it's one that I think organizations are increasingly becoming aware of the need to take action. That doesn't necessarily translate to an understanding across the business. I've spoken to a number of people in different organizations who simply don't seem to be able to put the risks that are posed here together with the potential consequences. And that's a real challenge because you can't do this type of compliance without the necessary resources. And so getting buy-in from the executive, getting buy-in from risk and finance, from legal is really important to be able to address these problems. And then I'd say the third element, the third issue in this space is probably a lack of internal knowledge. This is a very specialized or even subspecialized area. And so actually implementing systems that can manage these forms of risk can be challenging. So to drill down just a little bit further into these three areas, the employer sanctions, if you recall, these were the laws that were introduced in 2013 to make sure that employers only employ people with a valid visa and with the correct work rights. Now, again, this operates on a no-fault basis. What does that mean? What is a no-fault basis? Essentially, it means there doesn't need to be knowledge or understanding on the part of the organization that you are breaching the law. Okay, so, to translate this into fairly sort of classic legal terms, murder requires an intention to go out and kill someone. That intention is not relevant for the purpose of these laws. And that means that if you don't know you have to check someone's visa status and you don't, then you're still going to face the same penalties as someone who knowingly does the wrong thing, or potentially. Interestingly, it also applies to labour hire and contractors. So there are some risks there around having people on your work site who do not have the right visa. There are some ways to limit that liability, but it is still something to be aware of. Now, the actual prohibitions themselves, I'm missing one there, but allowing or continuing to allow an unlawful non-citizen to work, allowing or continuing to allow a non-citizen to work in breach of a visa condition. Now, where might you employ someone contrary to a visa condition? An example would be an international student who's limited to a maximum of 40 hours per fortnight, i.e., half time, 20 hours a week. If you allow them to work beyond the 40 hours per fortnight, then you are potentially in breach of that rule. Number three, referring, and this is in a sort of labour hire context, referring an unlawful non-citizen to work or referring a non-citizen to work in breach of a visa-related condition. Okay, so there are the prohibitions. Now, the penalties vary quite significantly from a warning all the way through to an aggravated offence, which gives rise to liability of up to 5 years imprisonment. Now, just to run through them, an infringement notice is essentially the lowest level of paid penalty. There's a civil penalty, again, no fault required. Criminal offences are only relevant to individuals, of course, but criminal offences can occur in this sector because there is liability for executive officers. And an executive officer in this context can be a CEO, a CFO, director, or a company secretary. So if the organisation employs someone who doesn't have the right visa or doesn't have the right to work, then there can be personal liability for the organisational directors. Now, it doesn't have to be knowledge. You don't have to know that you're in breach. You merely have to be reckless or negligent as to the breach. So that's quite a wide range of potential risks and potential liability. In terms of defences, the only defence that is available in this context is set out in the legislation, and it is that you have actually taken the necessary steps to check that a person had the right to work, either using the Visa Entitlement Verification Online system, or that you've cited relevant documents that are set out in the regulations, such as an Australian passport or a New Zealand passport. Now, interestingly, this doesn't sort of capture everything. And what I mean by that is it is possible for a permanent resident or a New Zealand citizen to lose their visa, but the legislation essentially removes that responsibility from the employer. Okay, so once someone becomes a permanent resident under the laws, you don't have to continue to check that they have the right visa. That probably raises another important point. It's not just about that first point of contact where the person comes in and applies for that job as a janitor that you have to check that they have a visa. If they're on a temporary visa, you have to continue checking. Now, there's nothing specified in the legislation about a particular period, but over time, our position has essentially been a minimum of once every 3 months. You need to be checking that people have the right visa. Okay, because visas can be cancelled for a whole variety of reasons that you as an employer will never see. And one of the examples that I often give is that in Australia, your visa can be cancelled, not for being convicted of a crime, but merely for the delegate at the Department of Home Affairs having a reasonable belief that you have committed a crime. So it is possible for people, employees who have a life that you as an employer never see, to lose their visa over misconduct or whatever it may be. And you will not know unless A, that employee tells you, or B, you do a Vivo check, because the government doesn't come to you and tell you, oh, by the way, this employee's visa has ceased. It is your obligation as an employer to continue to check and maintain an awareness of whether or not that person has a valid visa. So that's really important to understand. Moving on to the sponsorship obligations. As mentioned before, all employers who sponsor overseas workers have an ongoing obligation in this area. And this set of obligations function a little bit like what I would call a statutory contract. Okay, so it's an agreement between you as a sponsor and the Department of Home Affairs. But unlike a normal contract, the department has the right to alter those conditions without your consent. Okay, so you've basically signed up to a set of conditions that you will abide by, but those conditions may alter in future. And they're actually set out there in the table. So they apply to both business and employees. That's really important to understand. It's not just the visa population or the visa holder cohort within your organization. There are specific things related to your organization, and they may not be things that you would typically associate with immigration obligations or immigration compliance. They include things like a change of directors. Okay, so if your company or organization operates under a board of directors, every time there is a change to the board, you are supposed to be notifying Home Affairs. Failure to notify is technically a breach of your obligations and can give rise to a penalty. So it's really important to sort of understand what these obligations are and map them out, and how you as a HR representative or immigration stakeholder for your business are going to be aware of those and maintain that information and notify the Department of Home Affairs. Okay, so there's a lot there. Not all of these apply to the temporary skill shortage 482 visa. The one in the centre, for example, secure an offer of a reasonable standard of accommodation, only applies to certain visa types, right? But for the most part, these are generally the sponsorship obligations that apply. So keeping records, ensuring equivalent terms and conditions of employment, cooperating with inspectors, paying travel costs for the person to leave Australia, not engaging in discriminatory recruitment practices. Okay, so there's a whole bunch there. And as I say, there are some more significant ones, such as that pay travel costs to leave Australia and pay costs to locate and remove unlawful non-citizens. Now, the penalties for breaching your sponsorship obligations are quite interesting. They're interesting in the sense that they specifically now include the potential for negative publicity. The Department of Home Affairs must publish information identifying sponsors who have breached their obligations. So there is now a public list, which is updated semi-regularly by the Department of Home Affairs, which sets out who has been, which organizations by entity name, who has been sanctioned, okay? That's probably one area of liability that many people would not anticipate in this field. Cancellation and bar. So if you're found to have breached, and it's it's not necessarily a particularly high threshold. For example, I had a client a few years ago who was found to have underpaid a visa holder by about $500 over the course of the year, and their sponsorship was cancelled for 2 years. They were barred from using their sponsorship for 2 years. Okay, so I mean, underpayments, full stop, are probably regarded as quite serious by Home Affairs, but when you take it into consideration, $500 and then losing access for 2 years, that's quite a high sort of. The penalty is quite significant considering the potential inadvertent nature of the breach. You can receive a formal warning. You can receive an infringement notice for conduct in the last 12 months, and you can receive a civil penalty, okay? And as you can see, the charges are per breach, and quite often in this space, it's not one breach, it's 10 breaches or 50 breaches, because of the nature of the offence. If you're allowing an unlawful non-citizen to work, it's not one penalty for letting them work for 6 months, it's multiple penalties. Okay, so often penalties in this area are multiple in nature. Now, charging for a migration outcome. As discussed before, this is intended to stop people from perverting the immigration system by gaining a benefit in exchange for using the immigration system in the wrong way. So both sides are prohibited from certain forms of conduct. Someone who is seeking a visa is prohibited from offering or giving, okay? The gift doesn't have to, the benefit doesn't have to actually change hands in order for there to be a breach of the law. You only have to offer in order for there to be a breach of the law. And the same on the employer side, you only need to request the benefit to breach the law. The penalties are quite different, obviously, between individuals who are seeking a sponsorship and organizations who have the power to give sponsorships. For individuals who are seeking a sponsorship, they can face civil fines and visa cancellation. For organizations who request or receive a benefit, they can face similar penalties to the other regimes. So infringement notices, civil penalties, criminal offences. And again, there is personal liability for conduct within the organisation by the broader organisation by those executive officers. And the scenario I often give in this example is if you hire someone as a supermarket manager and they are found out, wrong example. If you operate a chain of supermarkets and a regional manager somewhere in whoop-de-doo has someone come in and say, hey, I want to be sponsored for a visa. I'm really desperate. I'll give you $20,000. And that supermarket manager says, yes, no problems, we'll sponsor you. There is liability unless you can mount a defense. And the defenses are that the organization took reasonable steps to prevent the offense from occurring. So there really needs to be training provided to people who have the power to make those decisions, that they cannot engage in this type of conduct. And then the other defense is the action that was taken once the organization or the individual became aware of the breach. Okay, so there is a lot of liability here. It depends on how organizations are structured. You know, organizations who have a really centralized HR system are obviously got lower level of liability here, but organizations where there are multiple hiring managers in various capacities who have different authority probably have more exposure in this area and probably have a bigger job to do in terms of pushing out that training to mitigate their own liability as an organization. So future changes. About this time last year, the Department of Home Affairs, partially in conjunction with the Attorney General's Department, floated a draft bill called the Protecting Migrant Workers Bill 2021 for comment by industry. And this bill essentially built on the work that Allan Fels, Professor Allan Fels, had done as the chairman of the Migrant Workers Task Force. Now, you may or may not recall, Professor Allan Fels was initially engaged by 7-Eleven to manage their repayment and plan to redo the way that 7-Eleven managed temporary visa holders. He was terminated from that job and quite promptly made the chairman or co-chair of the Migrant Workers Task Force. And the Migrant Workers Task Force spent about 24 months working across government, looking at all the potential areas of risk for exploitation, not just of temporary visa holders, but in general. And not much happened. I think they reported in about 2018, and then basically there was very little or no movement until last June, where we got this draft bill. And this draft bill was quite interesting because it basically set out a plan to allow the government to expand its migration control beyond sponsored visa holders. So we've got our sponsored visa holders such as 482, 494, training visa holders, etc. These are people who are actually sponsored by the organization. And in contrast, we've got non-sponsored visa holders, which would be students, working holiday makers, graduates, all these people who don't actually have a direct sponsorship by the organization. So the government is basically looking at expanding control to that cohort. And the way they would do that is by introducing two new offences. The first one would be a prohibition on coercing visa holders to breach their condition. And this, again, comes directly from the sort of revelations that came out of the 7-Eleven investigation, where unscrupulous employers had someone come in on a student visa and they would say, okay, so, this is your first week of work, you need to do 30 hours. The person would do their 30 hours and they would be in breach of their visa conditions. And at that point, the unscrupulous employer would say, well, now we basically have information on you that would mean the government would cancel your visa. So you've got to do all of these other things for me, like accept less money, accept below award wages, all these sort of things. This law is intended to stamp out that type of conduct. Okay, great idea. I don't know how well it would work. We certainly put in recommendations as an organization, but that's the proposal. And along with that, the bigger picture offence is that organizations would be barred from sponsoring any temporary visa holder or any, non-sponsored temporary visa holder for a period of 12 months if they were found to breach not just this rule, but any of the immigration sponsorship rules and potentially some fair work laws. So that would be quite devastating from an operational perspective for many organizations to lose access to non-sponsored visa holders, particularly in sectors such as hospitality and retail, where they rely very heavily on student visa holders and working holiday makers. So it's uncertain where the priority for this law sits with the current government, But I suspect that there will be a much stronger presence in the enforcement field under the Labor government than there was under the last government. And it will be interesting to see whether this is taken up anytime soon. But good to be aware of it, I think, because it's quite a significant rule. Now, in terms of managing risk, here are the key things that we recommend as an organisation when talking to our clients. Firstly, it's really essential that you have an immigration policy. I would say that 95% of organisations do not have an immigration policy, despite having a really significant visa holder presence. This is really critical because it does some really basic things. Establishes ownership, who is responsible for the different components of the migration program within your organisation. It sets out responsibility. Doesn't all have to be with one person. It doesn't all have to sit with HR. It doesn't all have to sit with, a particular person. It can be spread out, but by documenting it, it's clear and transparent. It also, of course, implements controls and processes. It should set out policies for how do we go about checking that someone's got the right visa. Who do we ask if we are unsure? Is there someone internally who's the knowledge source, or do we take it external? Do we, when someone who's already an employee, for example, comes to us and says they want to be sponsored, how do we make that decision? Like, is it based on salary? Is it based on occupation? What's it based on? These sort of factors, because that's really important for equality of treatment in particular, and can become quite an area of resentment within an organization if particular people are being sponsored, but others are not. And having transparency around that is really important. And it also provides a framework for, line managers and others within the organization to understand how and when these things happen. The second thing is a risk matrix. Really important to understand where are our areas of exposure and what are we going to do to manage them. So this really marries in with the immigration policy as a tool to sort of identify where are the potential trouble spots in the business from an immigration perspective and what can we do about it. And then, of course, audit. So once you've got your policy in place, once you've done your assessment against your risk matrix, it is necessary to come back, whether it's every 6 months, whether it's every 12 months, and actually check both your visa holder population. Are they where we think they are? Have they left? Have we made the notifications we were supposed to make? And then once you've done that, identify any gaps in your existing policy and process and make sure it's updated. Okay, so it really is a cycle. It really is a cycle about, setting the policy, reviewing the policy, reviewing your visa holders, and then, going back to the start again. Well, now we do actually have a risk matrix that we publish. It is available. And I will circulate it after the session. Okay, it just goes some way to sort of setting out, where are the potential areas of concern? What should we be worried about? What should we be looking at? And it's hopefully a useful tool for sort of identifying where are the significant risks, what do we address first, and what do we address, further down the track when we've got the time and the resources. Well, now, last but not least, alternative solutions. One of the things that we have identified as a business, and I've been doing this now for about 15 years with some of the biggest organizations in Australia through to, local startups and small organizations, almost no one has full compliance across the board. It is very challenging to do so. And one of the reasons that it's challenging to do so is most people are trying to manage these obligations out of spreadsheets. And that really doesn't work. It just doesn't have the degree of automation. It doesn't have the resources that you need. So as a business, we went out about 2 years ago and we started building a product for organizations to manage their immigration compliance. And what we've come up with is essentially a platform called Complies. And you can see there, the little logo is actually the 3 arrows, which sort of symbolize that sort of circular process of, or in this case, triangular process of compliance. We've got 3 modules: workforce management. Now, I describe this as a HR platform for visa holders. It basically means that you can track and manage visa holder data through the entire life cycle. Someone comes in, they want a job, you can check the visa status, and then when yes, they've got the right visa, okay, great, put them in the system, and then you can set it to automatically run those visa checks every month, every week, every 3 months, what you want. But also, as that person's role within the organization changes, you can update the position descriptions. You can, if you've got obligations, as you would a 482 visa holder, to notify the Department of Home Affairs if there's a change of job, then you can put that notification through the system. It comes to us. It comes to trained immigration lawyers who will look at it and make a determination. Is this something that can just go to Home Affairs without any problems, or does it raise any red flags? And if it raises red flags, then we come back to you and we say, hey, this is a potential issue, and we can discuss it. So that's like a HR platform for visa holders. Then we've got online training tools. These tools are for both visa holders as well as line managers and stakeholders. They're things like compliance modules, the same as you might have to do OH&S compliance modules or anti-money laundering and terrorism compliance modules every year. Everyone in the business, from just a standard employee, visa holders, line managers, HR and executives, they have short courses, 15 minutes to do once a year, that basically explain what your obligations are. What do you have to understand about immigration? Things like the charging for a migration outcome, making sure that anyone who has HR authority or hiring authority knows that they can't ask for a benefit, for example. We've also got full online courses about immigration law that are probably equivalent to a module, or a single unit at university, to bring someone who is new to HR or new to immigration all the way through up to being very experienced and competent. We've got knowledge libraries. So many people rely on the Department of Home Affairs information on their website. It's often inaccurate. It's often incomplete. We've basically got a Wikipedia of immigration knowledge, as well as all of the templates and documentation that you might need that you can generate through the system for the visa holders. So letters of support when they go to apply for a visa and so forth. So for example, here is a screenshot from the workforce module. You've got your visa holders there, record their salary, their line manager, their positions. We can run the Vivo checks through there and maintain all of that data, make notifications to the government, so forth. We can also do audits. So there is a process in there where you can set the system to run an audit every 3 months, every 6 months, and it will pop up for each individual, and it will say, okay, Jim Daly, is he still employed with the business? Is this still his position title? Have there been any changes? Is there anything that you need to notify about? And so you actually run through the entire workforce to make sure that there haven't been any changes there. Training, as mentioned, we've got those compliance modules, we've got courses for stakeholders and managers, and then we run webinars along these lines based on current topics for people to understand more about immigration law. We've got knowledge base, which includes that Wikipedia of immigration information, as well as those smart documents that I'm talking about, templates and checklists to use as a business. Make sure that, when you give that information to Home Affairs, when they ask for a job description, when they ask for a letter of support, it's got all the relevant information and you can just generate it straight out of the system. So at the moment, we're looking at rolling out the product. We're in discussions with a number of organizations in the healthcare sector and the agricultural sector, actually. And basically, the product's offered on a very similar basis to a HR platform, an annual charge per head. We can set up users with different statuses, of course, and all the sort of things that modern software does, run reports and all this sort of thing for you, tell you who's completed training, who hasn't done training, and so forth. So if you're interested, feel free to reach out. I'd love to speak to you about how the product might be able to, reduce the administration, reduce the burden of managing the program, make sure that you're ticking all the boxes in terms of immigration compliance and covering off all of the things that we've talked about. Now, that's the end of the session for today, but I'd love to hear if you have any questions. Feel free to, pop up in the chat, or if you'd like to actually speak, just let me know and I can set the program to No, no questions. All right. Well, thank you everyone for joining. It's been really great to have you here. I hope that's been of benefit to understand a bit more. If you'd like to know more, we do have template immigration policies. We've got, we can customize those to your organization. We can provide further training on the different aspects of immigration law and how it affects your organization. Always happy to talk. So please feel free to shoot me an email or give me a call. But otherwise, thank you very much for your time today. It's been a real pleasure. And I hope you've gained something new from today. Thank you, Leanne. Oh, sorry. Thank you, Louise. Have a great day, everyone.